Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law, estate planning, and guardianship attorney in New York. Today, I'd like to tell you about an interview that I had on the field of guardianship law. Before I get to that, if you'd like to make an appointment with me, if you'd like to speak with me over the phone, please go to callfrankbruno.com. Today, I interviewed a gentleman that is a court-appointed guardian for his mother. So there was a situation, I guess, in the past where he had to make an application for the benefit of his mother, and he was, pursuant to a hearing, appointed the guardian for his mother. Now, one of the reasons that he came to me today is that his mother needs an estate plan to take the assets that she has and to make herself, and he on her behalf, make her eligible for potential long-term care events. So he came to me today and we were able to speak about the issues, but two things. He did not bring the guardianship order and he didn't bring her existing last will. And in the conversation, he sort of referred to the last will in the way that someone would also refer to a power of attorney. Now, I believe that he didn't have a power of attorney because the guardianship was necessary, right? Or else that document may have precluded the need for a guardianship. But when he was referring to the last will, this potential client was using language like, this is what my mother wants me to do with her assets, and this is what my mother wanted me to do. And now, I think it was all in the frame of reference as to upon her death, but if he has no power of attorney, and I believe that he doesn't, I need to look at the guardianship documents to see if he has the ability to plan for his mother while the court is overviewing the situation, right? So the court has oversight of the guardianship. Now, so we made an appointment for next week. I was able to speak around the issues, but I couldn't have him hire me today, and I couldn't go further until I see those other documents. Now, he's going to come back in with the guardianship order, the judgment, and the last will next week. And but what I'm looking for is in the original judgment, having the court give him the authority to plan for the mother's estate. Now, more than I have no idea. I've seen it where the court does give the guardian the ability to plan for the possible need for Medicaid. And I've also seen the judgments not have anything to do with planning for long-term care costs or applying for government benefits. I've seen it in both instances in these guardianship judgments. If it is silent on the issue, we will need to make an application to the court for the ability, for the authority for this guardian to set up a plan for his mother. It will involve probably shifting assets from a non-protected status to a protected status, from countable assets to moving them to non-countable assets, right? Things that can be done for the future benefit of his mother and the totality of her estate. So if you have a situation where you'd like to speak to me about this or any other elder law issue, please go to callfrankbruno.com. Thank you very much.